The U.S. Court of Appeals for the Fourth Circuit issued an important ruling in an FLSA lawsuit that may affect a lot of employment lawsuits moving forward. The case is called Rogers versus Tug Hill Operating, and the plaintiff's lawyer is my friend Rex Birch. The plaintiff worked for a Texas company called Tug Hill in West Virginia for about a year and a half, and he sued the company when they didn't pay him overtime. Tug Hill's lawyer responded to this lawsuit by filing a motion to dismiss, saying that the lawsuit is subject to arbitration. However, there's no arbitration agreement between Tug Hill and Rogers. Instead, the arbitration clause is between Rogers and a headhunting company called Rig Up. Now, the defense lawyers were aware that the arbitration agreement was only between Rogers and Rig Up, and it states that Rig Up will not be a party to any dispute between Rogers and Tug Hill. Understandably, Rig Up then tried to intervene in this lawsuit, saying they want to arbitrate the dispute, even though they're not being sued for unpaid overtime. The district court made a mistake in granting the intervention and granting the dismissal. On appeal, the Court of Appeals held that the arbitration agreement clearly is between only Rig Up and Rogers. So Rig Up is not being sued, therefore they cannot intervene and enforce an arbitration agreement. One of the cool issues on the appeal is whether or not the judge or the arbitrator is the one to determine whether or not this case could be arbitrated. So the Court of Appeals held that it is the judge's responsibility to make a determination based on state law on whether or not there was a contract, and before they can compel it to arbitration. You can't bypass that part and just go straight to arbitration and let the arbitrator decide. So when it comes to state law, both West Virginia and Texas law, contract law, has a presumption against third-party beneficiary between two parties. So if Roger has an agreement with Rig Up, there is a presumption that it does not benefit a third party like the ultimate employer in this lawsuit unless they specifically agree to it. This ruling is important not only for overtime lawsuits, but employment cases overall, because a lot of companies in different industries are using personnel or headhunting companies to hire and retain talent. This case pushes back on some lawyers' effort to interject their client into existing contracts that they were not part of in the first place, and overall it gives some predictability on contract interpretations moving forward. Okay, back to work.